was disability and then race. And then in employment, it was retaliation and then race. We received monetary benefits to the complainants, and approximately $219,000 were received through mediations, conciliations, and settlements. Okay, it looks like I'm having a trouble with this advancing the slide. Are we sharing? There we go. All right. This project that we're doing for this webinar, our state law is the substantial equivalent to the U.S. Department of Housing and Urban Development for HUD. And so we were able to receive funding to provide educational events. In addition to this event, we will also host another webinar on April the 18th covering the fair housing laws and some case examples during Fair Housing Month. The objectives for this webinar, we're going to be covering identifying the elements of the allegations, identifying the steps in an investigation, and identifying critically thinking skills necessary to conduct the investigation. Before we get into all that, I wanted to talk a little bit about the Human Rights Commission and what we do. The Commission is an independent state agency. We are responsible for enforcing the state's anti-discrimination laws, which prohibits discrimination in housing, employment, and public accommodation. Since 2009, we've also ensured that the state of Tennessee was in compliance with Title VI of the Civil Rights Act, whereby state agencies receiving federal financial assistance, and that is on the basis of race, color, and national origin. Our mission for the Commission is to safeguard individuals from discrimination through education and enforcement. The applicable laws that we are going to be talking about for the investigation is the Tennessee Human Rights Act, and it prohibits discrimination in employment, public accommodation, and housing based on the protected classes. And it also includes the Tennessee Disability Act, which is the employment discrimination based on physical and mental disability. The applicable federal laws is Title VII, the Age Discrimination Employment Act for 40 years of age or older, the Employment Pay Act, which covers sex-based wage discrimination, the Americans with Disability Act, which covers the physical and mental disabilities, and the Fair Housing Act. So with all of those put together, we end up with 9 protected classes covered under each the state and or the federal laws. So the first thing that we do when we receive an inquiry, we first must establish jurisdiction. And we check jurisdiction at every level, at intake and when the investigator receives the investigation, and at the review stage prior to closure, just to make sure that our agency was covered to enforce the law over that case. So some of the questions that we look at is this the person over 18? A minor who may work at fast food restaurants when they turn 16, they may have a job, but they could not file on their own until they're 18. If they had a problem, they would need to have one of their parents file on their behalf. They must be complaining about an employment, a housing, or a public accommodation action that's covered by our laws and in Tennessee. Is the person complaining because of a protected class? And that's on the previous slide. We talked about that. And is the complaint timely? For the state, it is 180 days from the last action. And is the employer covered by our statutes? Meaning, do they have the number of number of employees, which is 8 or more for us, or 1 unit? Other matters that you must consider: are there any special circumstances or exemptions from the law that the provider can have? Does the complaint have the complainant's original signature? And once it gets the investigation, have you read the intake notes to see if there was any other issues raised about this complaint? So the investigator's role is really just to investigate this in a neutral and fair and accurate investigation, and to assess whether there's been a violation of the law. All investigations involve an accumulation of facts, so facts gathering relevant to the bases and the issues, and then which applicable law it applies to. So the first thing you do when you get a complaint is you want to make sure you develop an investigation plan. An investigation plan is just a working document that will help you guide yourself through the investigation. It lays out each basis and each issue, and it'll keep track of all of your actions taken, and then identifies what still needs to be done. So the first thing, you want to identify the information needed separately for each basis and issue. You want to apply the appropriate theories, and those theories are desperate treatment, desperate impact, retaliation, and harassment, and we'll talk a little bit further about those. You want to make sure and see if you need to go on an on-site. Sometimes on-sites for employment are helpful when you have a lot of documents that you want to look at, or if it's a disability case, it's nice to go on-site and see the work area or the home that they live in, that's the issue that they're having. Or if you want to just request a RFI, which is a request for information. You want to be able to review what the respondent's defenses are. What are they saying, what happened, and how they are supporting the decision that they made. And then you want to kind of make a preliminary analysis of the data that you have already and what else can take place. Who can answer the questions that you have, and who might you want to interview? So some of the theories of discrimination: the desperate treatment, that's when you're looking at a person has been treated differently because of their race, color, creed, sex, national origin, religion, all the protected classes. And the difference between that is desperate impact, and that is really focusing on evidence of like a neutral policy, but it has a discriminatory effect on certain people. So it could be a very simple policy, but it has a discriminatory effect. So that's going to be desperate impact. Harassment, that's unwelcome verbal or physical conduct based on one or more of the protected classes. There's 2 of those. It can be hostile environment, where you're looking at it to see if the evidence shows that the conduct was sufficiently severe or pervasive as to interfere with the employee's ability to perform their job or to live in their home. Or quid pro quo, which is the Latin term, this for that. And so the evidence is showing that submission to or rejection of the unwelcome conduct was based on an employment or a housing decision. And then the last theory is retaliation, that it's unlawful for a landlord or an employer to take action against an employee or a tenant because they participated in the process of a complaint, or they opposed a practice, or they assisted someone in filing a complaint. So retaliation is interpreted very broadly so that anyone can participate in that, and it's a large coverage. So in the investigative process, the first thing you want to do is find the evidence. So evidence is simply what facts were gathered against the allegations. So it's the availability of facts or information gathered through an investigation indicating whether a violation occurred or did not occur. It can come through testimony or statements, which is why we do witness interviews. It can be writing, so that's requests for information can be submitted, or it can be a material object. So evidence can be direct or indirect. Direct evidence is basically first-hand written documents. First-hand knowledge could be on the written documents. We kind of rarely see this happen to be, directly find evidence that can say that somebody discriminated. But we had a case where a landlord admitted that he denied a housing opportunity for a person that was Asian because he thought their method of cooking would damage their apartment. And he was speaking of the open wok cooking for stir fry. So that was pretty direct evidence, and we were able to cause that case. Most of our cases rely on indirect or circumstantial evidence, where we have to base our decisions on what we can infer on the evidence. When we pulled all the facts together, what story did it tell us? And we do that through comparative or even sometimes statistical evidence to bring that together. So comparative evidence is looking at individuals around them that are similarly situated persons outside the individual's protected class to compare them to the complainant to see what happened. So questions that you would ask, for example, is what was the similar wrong act and what happened to them and who made the decision? And that's going to help you with the inference. Or statistical evidence is, has the decision maker hired the same person as complainant on par with the labor market or the applicant flow, or fired them with the same analysis? So basically, what's the manager's track record? Similarly situated, we kind of talked about this, but it's a person who committed a similar in kind or a similar in effect wrongful act. And so the characteristics that you want to look at is, was the person supervised by the same decision maker, and did they commit the same act? So for example, an African male gets into an argument at work, the supervisor suspends them. Conversely, a Caucasian male throws a punch at work, and the supervisor just does a written warning. Why? So you want to find out what was the difference between that. So once you have your investigative plan and you know what the allegations are, and you're ready to try to talk to and confirm allegations and find out more information, we generally start with the complainant, and that's the person bringing the charge. So when you're talking to them, you first want to confirm the allegations, because most of the time things are sent to us in the mail, and we have to read through, but you always like to hear what the complainant says firsthand. You want to make sure the date of the incident, what the date of the incident was, and then probe for relevant information. But try not to get lost in the weeds or in the details that are outside of the time frame of that 180 days, or are just off target to what the initial allegations were. You want to use your IP to stay on track to what's relevant. Make sure you get the specifics, no generalities. Clear when they talk about who they, ask who that was. When they use phrases like all of the time, try to pin down when and how often. And if they say stuff or things, you really want to try to get very specific as to what was that. So I provided a case example that we had that we'll use throughout the rest of this webinar. So complainant's allegation. Complainant stated her monthly rental payments is due on the first of each month, and if rent is not paid in full by the fifth day, a $50 late fee is incurred. Complainant alleges that due to her disability, she is unable to work, and her sole income is from Social Security, which is received on the second Wednesday of each month. She alleges to avoid the late fee, the complainant verbally requested respondent to move her due date to the second Wednesday of the month as a reasonable accommodation. When respondent did not reply, complainant alleges she mailed her reasonable accommodation request to the respondent and asked that he reply by a certain date. She alleges that he failed to respond to the request and continued to accept her rent plus the $50 late fee. So this is a complaint that we received, and so once we look at it, we accepted it for disability, and it was for a reasonable accommodation. So some of the sample questions that you'd want to ask, you'd want to establish first that the complainant has a disability, and you can do that by just simply getting a copy of her Social Security income check. This would be enough to establish the disability because she would have had to fill out multiple paperwork to be able to apply for that. You want to find out all the dates of the times that she made the request and what the request looked like, and if she has a copy of those, to ask those to be provided as well. Or if she did it verbally, if you can try to pin her down to how many times that she did it verbally. And then ask what was the respondent's response. She says that he did not respond, but you want to say, did anything happen? Did he talk to you anymore? Did he ignore you more often, or something like that? You want to ask how many times has the rent been late, so you can kind of see how long this has been going on, and if there was any witnesses to the request. There may be other questions, but this is just what I came up for right now. So asking for witnesses are important because those are those independent people that you can follow up with to find out what was actually going on at the time, and they can corroborate the complainant's allegation. You can obtain as much evidence as possible and gather any written documents, notes, emails, computer recordings. And you would make the same request of the respondents. Sometimes respondents will send a lot of information that may not even be relevant, so you really like to try to pin them down and ask for very specifics. Even if we receive statements in the position statements or the statement of positions that they send to us, if there's like written statements in there, we still want to interview the person to verify that that this is what they actually said. So you want to verify and emphasize that it's very important to send positions and to assert what their defenses are. Again, for them, you want to get specifics. If they're referencing documents like attendance documents or records for late fees and things, that you want to make sure you can gather all that information. Provide a time frame for them to respond to you. Sometimes they'll just leave it on their desk if you don't. Let them know how you're going to use the information, and then always ask for similarly situated employees. So for our case example, this was what our respondent did. He did not provide a written response to the charge. And when the investigator called, there was disconnections. Not sure what happened, but we were disconnected and we were not able to get a reply. However, a couple of months after the complaint was received, the complainant called to inform us that she'd received a letter from the respondent indicating a rent increase. So we were able to amend the complaint and add retaliation. So it's very important to get interview witnesses, which are third parties. It's really good to get people who are not invested in or don't have an outcome in the complaint. Usually the complainant will provide witnesses, but it's also good for the investigator to develop witnesses. So if you're in tenant, if it's in a housing unit, you can call on other tenants. Sometimes we do on-sites and just knock on doors and just start asking questions of people depending on what the allegations are. We always want to interview all witnesses separately so that you can get their view of what is going on and not have a corroborated statement. And always reserve the right to say that you're going to re-interview or need to call them back. So some of the things that you can you have to guard against is perception versus fact. The investigation needs to be based on facts and not gut feelings. Sometimes we can use our gut feelings to think, oh, we can go this way, but if we don't have the facts to back it up, we can't say that it's cause. Decisions that are based on perceptions most likely are influenced by our personal prejudice, stereotypes, and our generalities. We want to make sure that we're neutral fact finders, that we always see the evidence through as clean of lens as we can. And you make sure that you get enough evidence to support any conclusion that you come to. And we all have different interpretations of facts, but decisions that are based on sound analysis, those are going to stand up better in court. Always good to remember you're investigating and not interrogating. So you want to try to make the witness feel comfortable. You want to make sure you know the facts of the case and be prepared before you call anybody to do an interview. You want to let the person know that you're taking notes so that if there's a pause in between the questions, they'll know why. Because we cover the state of Tennessee, most of our interviews are via the phone. You want to create an atmosphere conducive to gathering truthful and accurate information. Explain the purpose of the interview and how the information will be used. Another helpful thing to help witnesses want to participate, because it is voluntary, is you want to explain the retaliation rights for participating. They would be protected from retaliation for talking with you. Again, obtain any documents that person is referencing. Remain neutral and watch your tone, because if you only have your voice to have a response to, your tone can indicate that you're showing a bias or whatever else they may perceive. Avoid using you and why, and especially why in a negative tone, like why didn't you report it, could come off and put people on the defense. In all of the questioning that you're looking for, you're trying to get the who, the what, the when, and the where. And you want to ask open-ended questions so that you're able to allow the person to continue talking. So here's some examples of open-ended questions. A closed question would be, are you a janitor? A better one is, what is your job? And that allows them to talk. And you may find out more than you would have asked. A closed question, did you tell John? Open would be, who did you tell? If somebody is telling you something and they say, I heard this from, we call that hearsay, but you want to follow the source. So ask them where they heard it who told them when, and then try to talk to that person. You want to listen and ask good follow-up questions. Again, you want to interview people alone. You want to take good notes, label and number your pages prior to the interview so that's not a distraction. If you use shorthand, it should be consistent throughout. So if you have to share your notes with somebody, they're able to read it. Remember, there are no off-the-record remarks. And remember your notes. Re-review your notes after the interview to make sure you have all the information that you need. Another thing you don't want to do is to ask questions, the same questions, the duplicate questions in one question. So instead of did you go to the storeroom or to the workshop, you're limiting their response. So you just want to say, where did you go? So this is a question that we get all the time is, should we record? I mean, recording is optional. We don't do it here at the agency. Some of the pros is you can concentrate on listening and you don't have to write notes so much and concentrate on notes. It can be unimpeachable record. Some of the cons is the witness demeanor can be affected and you may not receive, all of the information that you want because it kind of just puts people on the defense. And, as much as we don't record it, we always recognize that we are being recorded. And we try to act ourselves that way because in Tennessee, only one person needs to give the approval of recording, and it could be the person who's actually recording. So we always act like we're being recorded. All right, so once we get to gathering all of our facts, we get to what we call the analysis stage. You want to review all of your notes, all of your documents, and your other evidence, and then we want to make sure, is it reliable? So you want to look at that test. So if we look at our case and we're looking at what source was firsthand, we got our complainant who provided the information. We assessed whether she was a person with a disability, and we were able to get the records of that. Whether the source had a vested interest in the outcome? Well, yes, she did because she actually filed the complaint. And was there original documents, or was it original documents or a summary? And we got the original letter that she sent to the landlord, and we got the original record that he sent to her on raising the rent. So does the evidence dispose of each raised issue? Yes, we were able to see that she had a disability, requested a reasonable accommodation, and in essence, the respondent denied the reasonable accommodation and then retaliated against her for filing the complaint with trying to raise her rent. And then look for corroborations, inconsistencies, impossibilities, and witness credibility. We were able to look at comparable witnesses to ask if everybody in the rental place received an increased letter for their rent and no one else that had. So if you're doing an in-person interview, you can look at the demeanor of the person to assess credibility. Are their statements consistent? Are they invested in the outcome? Like, do they have a motive for wanting it to spin it one way or not? Did they have bias? When was the timeliness of their reporting of the incident to kind of show motive? And you want to use the same standard in evaluating the evidence for both parties. Definitely want to review policies and procedures, and then go back to your discrimination theories and your laws to make sure you have everything you need in order to make a decision. So part of when we come to make a decision, we are able to offer mediation, which is an alternative to undergoing a full investigation. Parties can come together and kind of decide resolution. You can facilitate or negotiate a settlement based, and that can happen during the investigation. And in housing, we do a conciliation piece where the investigators kind of shuttle offers back and forth. So in this case example, we were able to cause the case on disability and retaliation. And so we didn't have to write a draft memo, but if we were going to write a draft memo, this is what it would look like. After you review all the evidence, you'll need to make a determination. So we reviewed the evidence in our case example and said it was cause. So our, what we call a pre-cause memo would look like a brief summary of the case, the evidence that CP submitted, the evidence that RP submitted, whatever witnesses were said, and then what laws we were using. And then and then our analysis piece is how did the evidence line up with the laws. And then we would submit it to our attorney or our ultimate authority for final action. So in this case, we said we caused it, and the complainant received $5,000 in monetary benefits and a written apology. The respondent also had to complete fair housing training and pay $2,000 to the commission for reimbursement of costs billed by our Secretary of State, which is when we caused the case. So once you've once you've done the investigation and you've come to your conclusion, you want to notify the complainant and the respondent in writing. So you make sure you just kind of follow your policy on that, and then provide any appeal rights. So bottom line, did you conduct an appropriate and fair investigation in which both sides were heard and given the opportunity to present their side of the story? So that's really what an investigation is. So I think the last part of this is we're going to be looking at some best practices. And this is how to limit liability if a complainant files a complaint against you. Just really develop good policies and make sure everyone knows them and that you enforce the policy consistently. So you want to communicate and distribute policies to everyone. You want to post them if you can, and then have a solid complaint reporting process. And as I have here, document, document, document. You want to conduct self-analysis to evaluate for processes for your recruiting, your hiring, promoting, how you discipline your employees, how your application process is, when you how do you your maintenance requests and any accommodation policies. Just review all of those and make any adjustments where necessary. And ultimately, we want to respond to all complaints promptly and effectively and take any corrective action. So, do you have any questions? I think the question that came up was, are we going to be able to receive the slides afterwards? And yes, we will send out this PowerPoint to everyone at the conclusion of this webinar. And this webinar will also be posted on our website. Any other questions? Oh, it looks like we have a question here. How often do you find for the respondent as compared to the complainant? Okay, so I think that's a question that we always get that says, how often do you find cause? Um, I think what we do is the first thing that we try to do is do mediation in all of our complaints. For the first 45 days, we send out mediation because we want to get to resolve the complaint on the first part if we can. Um, so we do that, and then I think if we do find cause, like in this case example that I had, we offer post conciliation, and so if that happens, then very rarely it resolves there, and very rarely does it go to the administrative law judge. So a lot happens before cause is what I guess what I'm trying to say. If I had to put a percentage on it, I'd probably say probably 10% of our cases are cause. Thank you. It says excellent presentation, great example. Thank you. Jenny Law is typing. Thank you. Any other questions? Somebody's typing. Okay. Uh-oh, we went past. Again, the slides will be sent out at the end. Somebody else asked that question. I'm missing a question here. Let me see if I can get it. What happens if in the course of the investigation you're wrong? um, you find, wait, uh-oh, can't see how. Jenny, I'm trying to get your whole question. What happens if in the course of the investigation you find wrongdoing on both sides? Okay. In that case, at the end of it, we talk to both parties, and we share what we're finding and allow them to respond to the evidence that we've found. And so in that, we probably would send that to investigation, and a settlement would probably come up out of that. Another question, what if the complainant quits responding to your request or stops cooperating? We do find this on occasion, and at the very beginning of our investigation, we always tell them that it's their responsibility to keep in touch with us, and if they change addresses or contact information, to remember and let us know. But if we can't locate them, we also have an alternate contact person that we ask for their information. And so if we can't contact them through themselves and them updating their information, or through their alternate contact information, then we will close it out as failure to cooperate. Somebody else is typing, so we'll give a few more minutes. While they're typing, again, we have another webinar on April the 18th. That's going to be during April Fair Housing Month. It's April the 18th, and I believe it again is at 1 o'clock. And we'll be talking about the actual fair housing laws. Okay, here's a question. Let me go back. Let's see. John Drummond says, can you say whether retaliation findings have increased or decreased over the past 5 years? They have absolutely increased. In employment especially, that is our um, top bases at this point. Another question, C. What was the 180 days? Is that like a statute of limitation for filing a complaint? Yes, for us it is we have to receive the complaint 180 days from the last action that you feel was discriminatory. Looks like somebody else is typing. While they're typing their question, it looks like Erica will be sending out a evaluation survey for you to do. If you would please fill that out. As I said at the beginning, this is funded by partnership funds with HUD, and they like to see evaluations back from the attendees, and and it also helps us in how we present and what topics we present on. Okay, here's another question. Has there been an increase in your agency's workload in the last 24 months? Yes, we've received an increase. What we do is we monitor all the phone calls that we receive in our customer service and how many forms are sent out. So we've sent out more forms and more forms have been returned. So our inquiries have increased. Any other questions? Okay, here's one. Um, let's see. We often delay taking appropriate performance management actions for fear of a retaliation claim. Any suggestions as to how to avoid or successfully defend? Well, so you just have to make sure you have policies and that you're following your policies. That's going to be your best defense. So, like I said on the other slide, is you want to review your policies, make sure everybody is trained, and then post them and follow them. So, uh, really following your policy, as long as your policy is not discriminatory, is really your best defense. And to make sure that you are applying your policy across the board. So what you do for one, you do for the other. There's some people typing. These are good questions. Okay, let's see. Kim manager, how is the determination made regarding which cases are referred to EEOC? Okay, so we have a work share agreement with the EEOC and with HUD. For us, it's 8 in employment. There's 8 or more employees. If it's 15 or more, then it's dual filed with the EEOC, meaning we're going to investigate it under the state and the federal laws. The only time they are transferred to the EEOC is if it's a disability accommodation or a religious accommodation. So 15 or more, it's dual file. So anybody can come to us, and if it meets our jurisdiction and it's within 180 days, we'll investigate it. If it's beyond 180 days, we'll also transfer it. We'll do the intake and transfer it to EEOC. Okay, thanks, Brian. He was asking a cross-reference with the EEOC, so I believe I answered that. Somebody else is typing. Must be a long question. They're still typing. Okay. Um, there's a question above by Gina Lewis that you did not see. Okay, let me go back and see. Oh, okay. Oh, I thought I answered that on the retaliation piece. But basically, I was saying that you want to review your policies to make sure everybody's trained on their policies. As long as your policies are strong and they're not discriminatory and you apply them correctly, that's going to be your best defense against retaliation. Okay, it looks like there's a couple of people still typing. We'll hold on for a couple more minutes. Again, while they're typing, remember the survey will be coming to you, the PowerPoints will be sent to you, and if you can turn those evaluations back in for us, that would be helpful. It helps us know what topics to do, and it also complies with our responsibilities back to HUD. You're still typing? It's going to be a good question, I guess. Okay, while they're typing, if you're going to be in West Tennessee at all, we do have a couple of other events. The West Tennessee Fair Housing will be on the 5th in Memphis at the Botanical Garden. So you're welcome to join us there. Okay, this is going to be a long one. All right, here we go. Since the passage of the Healthy Workplace Act, have you been processing complaints of workplace bullying, perhaps as a form of humiliation and embarrassment? Um, if they're not citing it as a protected class, like it's happening based on their protected class, then it would not come under our jurisdiction. So they would have to cite that they're being bullied or being harassed based on their protected class. Anything for investigators in Memphis? I'm not understanding your question, Cooper, EEOC. Um, The events in Memphis are going to be surrounding housing in April because of Fair Housing Month. You can definitely go to our website and let me see if I can pull that up right now. And I'll tell you about all of those. Thank you, Erica. She put the website out there in the calendar of events. Okay, wait, I'm falling behind on these questions. Let's see. Okay. Uh, Her question is, if you get a complaint that does not state a protected class, how do you handle it? Okay, we have two intake staff that receives all of the complaints from around the state, and they read through them for jurisdiction. And if the person does not state a basis or state a claim because they did not cite their protected class, then they call the person and talk through the complaint with them, talk through the inquiry with them to see if what they were saying. So we follow up that way. And if they're still not able to say that the reason something happened to them was based on their protected class, then we would close the inquiry out and we'd send them a letter allowing them and telling them why. How many units before rental units are covered? I think you said. Under the state law, the THRA, we just need one unit. There is an exception if the owner is living like a duplex, the owner's living on one side and he wants to rent out the other side, then he would not be covered. But if it's just a rental unit, then you would be covered as one for the state. We can dual file with HUD when there's four or more. Good questions. All right, it looks like you're coming to a close here. So let me just run through a couple of things. We have our employment law seminar coming up at Trevecca College here in Nashville, and that's going to be, oh, I can't see it, in June. Registration is going to be open in April, I believe. I believe registration is open. Like I said, in Memphis, we're having the West Tennessee Fair Housing Celebration, and that is April 5th, and starts at 8 o'clock, and registration is open for that. Remember, here in Nashville, the Fair Housing Matters Conference is open, and these are all going to be geared towards housing because it's in April, and so it's April Fair Housing Month. And that's going to be April 19th. And our employment law seminar is June 22nd. Okay, so we're going to wrap this up if there's no further questions. Um, Again, the survey is coming out to you. Oh, looks like somebody's typing. In a few minutes, the slides will be sent to you. And if you can respond to that survey, that would be great. Is there another question coming in? Oh, thanks, Sabrina. Very helpful. Thank you. April 18th is our next one. Erica will be sending it out for registration for that very shortly after this one. Thanks. Okay. Thank you all for coming, and we'll see you on April 18th. Thank you.